Greetings, sisters. I'll begin today's report by mentioning news specific to our chapter. We recently published a post authored by board member Lauren Levy on behalf of Lesbian Bill of Rights International titled Report on How UN Women Want to Reframe Male Violence Against Women and Certain Men. It speaks to her recent participation in a webinar hosted by UN Women titled Measuring Gender-Based Violence, Data Collection and Evidence on Violence Based on Sexual Orientation, Gender Identity, Gender Expression, and Sex Characteristics. And the acronym associated with that is SOGIESC. Lauren concludes that going forward, it seems predictable that the proponents of gender identity ideology, including UN Women, will increase their usage of the SOGIESC acronym instead of the LGBTQIA as a next step in their campaign to erase all women, including lesbians in particular, and to erase men and boys as the main perpetrators of violence universally. Additionally, I've been informed that WDI USA's amicus brief that will put radical feminist arguments before the Supreme Court in 2 sports cases is on track to be filed tomorrow. I'm also told that our brief cites Sheila on the prison of gender, as well as the April decision by the UK Supreme Court. And while we give heartfelt thanks to those who have already contributed to our legal case fundraiser, we're still $5,000 short of our goal. Any contribution you can spare to help us get over this last hurdle would be much appreciated. In a Substack post published last week, Kara credits attorney Glenna Goldis for drawing her attention to the fact that a federal judge in the District Court for Massachusetts has blocked a subpoena the DOJ had issued to Boston Children's Hospital regarding its involvement with performing sex trait modification procedures on children. The subpoena was one of over 20 that were sent to doctors and clinics in July when the DOJ began investigating these providers for fraudulent billing practices and more. The judge who blocked the subpoena, a Biden appointee and former employee of the ACLU, asserts that the department is not investigating fraud, rather that it is motivated by disapproval of the transgender community, and the subpoena issued for an improper purpose. As Glenna points out on X, improper purpose is an obscure doctrine for quashing subpoenas. It applies in extreme cases of corrupt government motive. As Kara says in her post, this is not serious judging. On Wednesday, in an X post, attorney Sarah Parshall-Perry shared some good news out of the 11th Circuit Court of Appeals. In a full court decision, the 11th Circuit ruled that it is not a violation of Title VII of the Civil Rights Act of 1964, which deals with employment issues, for an insurance company to exclude coverage for so-called sex change surgical procedures. Writing for the court on behalf of himself and 6 other judges, Judge Brasher, following the reason of the Supreme Court in U.S. versus Scrimeti, asserted that the exclusion does not treat anyone differently based on the protected characteristic. Disappointingly, on September 10th, the Supreme Court left in place a lower court order striking down a South Carolina law mandating separate sex bathrooms and locker rooms, and maintains an injunction allowing a trans-identified female student to use spaces designated for boys while her challenge to the law proceeds. Interestingly, however, in the brief unsigned order, the court emphasized that in denying South Carolina's request to pause the ruling by the U.S. Court of Appeals for the Fourth Circuit, it was not weighing in on the underlying merits of the challenge filed by the teen, but ruled based on the standards applicable for obtaining emergency relief from this court, such as whether the state would be permanently harmed if the lower court's rulings were not put on hold. What is also interesting is that Justice Gorsuch the author of the disastrous 2020 Bostock decision, joined Justices Thomas and Alito in saying that they would have granted the state's request, which would have allowed it to implement the law while the litigation continues, signaling that he may have learned something since authoring it. One can only hope. And finally, I'm pleased to share some good news for women cycling. Last week, I mentioned that USA Cycling had released a new policy, seemingly to help protect the female category, even as it appears to include a few loopholes that could conceivably allow men to compete within it. I also mentioned that the female cyclists I've interacted with were encouraged by the new policy and interested in seeing what USAC actually enforces in upcoming competitions. Well, it appears they were right to be encouraged. If the upcoming gravel national championships are any indication. According to a screenshot shared in a private Facebook group, male cyclist Kate KJ Phillips, whose theft of the women's championship title at the Lions Masters National Championships earlier this year sparked outrage, is currently registered to race in the non-binary/open category of that event, as opposed to the women's. And that's all I have today. Thank you.